Okay, good afternoon, everyone. My name is Bryce Wakefield. I am an Asia Program Associate, the Asia Program Associate for Northeast Asia here at the Woodrow Wilson International Center for Scholars, and it is a rare privilege to have at an event here a panel full of lawyers. It's also somewhat a distinction, I guess, to have a lawyer from a university in Washington, a lawyer from Washington University, and a lawyer from the University of Washington all on the same panel. I don't know if that makes things confusing or easier. But it's appropriate because, of course, our event today is on politics in the judiciary, or the judicialization of politics in Northeast Asia. Our first speaker on our panel is Carl Goodman. He's an adjunct professor of law at Georgetown University and at Washington University. He has 15 years of government service under his belt. He was with the State Department and the EPA for a while, as well as the Department of Justice. He has also spent 4 years, I believe, at Hiroshima University, and he is the author of The Rule of Law in Japan, A Comparative Analysis, and Justice and Civil Procedure in Japan. Our next speaker will be David Law. He's a professor of law and political science at Washington University in St. Louis. He was also the executive director of the Harvard Law Review. He's clerked for the Honorable Stephen Reinhardt of the U.S. Court of Appeals for the Ninth Circuit. He's also served as visiting professor at National Taiwan University, Seoul National University, and Keio University. He was also a visiting scholar at New York University. His articles have appeared in the New York Times, and they've been translated into Chinese, Japanese, and Romanian. And our final speaker will be Jonathan Kang. He's an assistant professor of law at the University of Washington. He has degrees from Harvard and Oxford. He grew up in Singapore, but was born in Seoul. And he clerked for Judge Robert A. Katzman of the U.S. Court of Appeals in the Second Circuit. He's the co-editor of the forthcoming book, Private Law in East Asia. So without further ado, I'll turn it over to these gentlemen, and Carl to begin with.
During the American occupation of Japan, the Americans had some very distinct views about Japanese law and changes that should be made in Japanese law. And one of the changes they suggested was a change to diminish the power of Japanese prosecutors through the creation of what became known as the Prosecution Review Commission. This was a second best alternative. The first best was the desire to create a grand jury along the lines of the United States. The Prosecution Review Commission, as originally formulated, were commissions throughout Japan. There are some 200 of them throughout Japan. They consist of 11 people who are elected for a 6-month term, approximately 50% change every 3 months. And their function is to review complaints or to generate their own investigations of cases where a prosecutor has decided not to prosecute a defendant, as distinguished from the grand jury, which usually looks at the prosecution's decision to prosecute a defendant. If a group of 8 of the 11 determined the prosecutor made a mistake, under the old law, the prosecutor was required to review its previous decision and either indict or come back to the review commission and explain why it was not indicting, and that was the end of the matter. In 2009, the law was changed to reform the Prosecution Review Commission by providing that if the prosecutor determined not to indict, then he had to explain that to the Review Commission, and if the Review Commission, whose membership, of course, by now would have changed, the Review Commission votes again by a vote of at least 8 people that the prosecutor should have indicted, then an indictment must be brought. And the indictment is brought not by the professional prosecutors, but by private attorneys who are appointed by the court, but in reality are appointed by the Bar Association to carry on the prosecution. To date, there have been 5 cases in which prosecution review commissions have twice decided people should be prosecuted, and thus prosecutions have gone forward under the amended procedure. The cases are quite interesting. One case involves a senior police official. Some junior officials were convicted of professional negligence for not properly handling a crowd control matter. The senior official back in the office at the time was not prosecuted, but after amendment of the Prosecution Review Commission law, he was indicted by private prosecutors. That case presents a serious statute of limitations problem because the statute of limitations for professional negligence expired before the Prosecution Review Commission reported a second time. That case is pending. The other involves a railroad company executive who was not in charge of safety matters, but there was an accident. Several people at the railroad, including the person most responsible for safety matters, were indicted by the professional prosecutors. The railroad company executive was not indicted. The Prosecution Review Commission determined that he should have been indicted, and his case is pending. In the interim, the official who was responsible for safety matters was tried and found not guilty. The third case involves an investment company official who was not prosecuted by the professionals, but again, twice the Prosecution Review Commission decided he should have been prosecuted. His case has actually gone to trial. The trial has been completed. He has been found not guilty. The fourth case is the case of the Chinese ship captain whose boat rammed some Coast Guard vessels of the government of Japan. You may have recalled, if you were following the newspapers about this incident, it created a great incident between China and Japan. Japan eventually sent the ship captain back to China to relieve some of the international pressure, notwithstanding Prosecution Review Commissions in Okinawa decided on 2 occasions that he should have been indicted. He has since been indicted. It is highly unlikely that he will return to Japan to face trial. And the last case is the case that I'd like to discuss with you, and that is the case of Ichiro Ozawa. Ichiro Ozawa is, we should first understand who he is. Ichiro Ozawa is one of Japan's most prominent politicians. He was a leader of the Liberal Democratic Party during the Tanaka prime ministership. He was Tanaka's protege when Tanaka fell from power. He, Ozawa, Takeshita, and Kanemaru literally became the head of the Tanaka group and ran Japanese prime ministership for a period of time. Ozawa was the Secretary General of the Liberal Democratic Party when Prime Minister Kaifu was the LDP Prime Minister. So he was a heavy hitter in the LDP. He broke with the LDP during the Miyazawa prime ministership and probably is responsible for having brought down the Miyazawa government because the people he were in his group voted against Miyazawa in a no-confidence motion. Ozawa then took these people outside the government, formed his own party. There was an election in Japan. There was a split of parties. Ozawa supported Hosokawa, and for the first time since, 40, 50 years, the LDP did not have the prime ministership, but Ozawa was very, very much responsible for Hosokawa's term as prime ministership. The Hosokawa government governed for about 9 months and then fell apart, and Ozawa was kind of put into the wasteland for a period of time. But he emerged later on with his own party and merged his party into a party formed by Hatoyama, and that became the Democratic Party of Japan, which for the first time won an election that ousted the Liberal Democratic Party and brought in what is now the current government of Japan. As a sidelight, I would note he's also responsible for the present election system in Japan, which is not the election system that had existed previously. Ozawa is the head of his faction in the Democratic Party of Japan. He's a principal fundraiser for the faction, and he was in the sights of prosecutors for the alleged improper filing of campaign finance reports having to do with a piece of real estate that was owned by his campaign finance funds. Question of where the money came from is murky. For that, 3 of his aides were indicted and have been convicted for filing a false report. They have since appealed. The prosecutors decided that there was insufficient evidence of guilt on the part of Ozawa and decided not to indict him. However, the Prosecution Review Commission disagreed and in 2 votes decided that the prosecutor was incorrect and that Ozawa should have been indicted, and he has been indicted. The indictment of Ozawa is significant for what we are talking about today because of its timing. Hatoyama was the first Democratic Party of Japan prime minister. He stepped down as a consequence of a financial scandal involving contributions to his campaign by his mother, who's a very wealthy woman. Ozawa stepped down at the same time. In a recent interview, Ozawa said that he was the person who suggested to Hatoyama that the 2 of them should step down at the same time. Remember, Prime Minister Kang became prime minister. The Democratic Party of Japan lost the 2010 upper house election. Many people say because they did not follow the game plan for that election that Ozawa had set forth, but rather followed a game plan that Kang had set forth. Kang refused to step down as prime minister. Ozawa challenged Kang in a race for the leadership of the party, which would have made Ozawa prime minister had he won. At that time, the Prosecution Review Commission investigation into Ozawa was public knowledge and was well known. Ozawa lost the race against Kang within the party. It is interesting to know that under Japanese law, a member of the cabinet can only be indicted if the prime minister agrees that the member of the cabinet can be indicted. Now, had Ozawa been elected prime minister, he would, of course, have been a member of the cabinet, and then had the Prosecution Review Commission determined he should have been indicted, he could only be indicted if he agreed that he should be indicted, which would have created quite a complication. How that figured into his loss to Kang is unknown, but certainly the people in the Democratic Party of Japan who were electing the prime minister effectively were aware of this complication. When Prime Minister Kang was forced to step down ultimately after the great East Japan earthquake and tsunami and the Fukushima nuclear disaster, Ozawa had been forced out of the party by Kang, his membership suspended, and therefore he could not run against Kang. But Ozawa was a force in the election of Prime Minister Noda. Not that he supported Noda, but that he did not support the principal challenger at that time for prime ministership, who was knocked out of the race, and Noda then became the viable alternative, and he, it appeared, was more acquiescent to Ozawa and actually brought some of Ozawa's supporters into his cabinet. Now, so Ozawa remains a force within Japan. It's also important to understand something about Japan's election law. Japan's election laws were enacted at the time of the Meiji government, all right, at a time when political parties were beginning to flex their muscle in Japan, and when the government, which was controlled by the Meiji oligarchs who had overthrown the Tokugawa regime, when the oligarchs were concerned about the potential power of these new political parties and wanted to limit their power. And so they brought in an election law which very severely restricts freedom of speech during the campaign period. So there are in Japan restrictions on advertising, restrictions on print and TV advertising. The idea of having a debate between candidates, such as we see here in the United States as a normal course of affairs, is impossible in Japan under the campaign restriction laws. Having a campaign by way of email is not possible under the campaign laws. You can have posters, but the number of posters you have, the size of the posters you have, that's all limited by law. You cannot go door-to-door canvassing. If you've ever been in Japan at the time of an election campaign, you see the election campaign on the street. There are cars driving around, and some candidate wearing white gloves is waving while bullhorns are shouting out his name, and that's about it. Each candidate gets, I think it's 5 minutes on NHK to present their position, and even that can be edited if it's considered impolite. These restrictions have all been upheld by the Supreme Court of Japan on the argument that they level the playing field between candidates. However, in Japan, a candidate can run for office either in a single-seat election district, such as we have here in the United States, or in the proportional representation election, both of which are held at the same time, and a single candidate can both be a single-seat candidate and a proportional representative candidate at the same time. The restrictions that apply to candidates do not apply with full force to political parties, and thus a candidate who is a candidate of a party and is also on the proportional representation roll, as well as in the single district role, has an enormous advantage over an independent candidate, because he gets the free speech benefits the party gets, but which the independent doesn't get. That, too, has been challenged under Japan's constitution, but the Supreme Court of Japan has upheld this difference between party candidates and non-party candidates. It would seem that that is not leveling the playing field, but nonetheless the court has upheld it on the ground that political parties are a necessity in today's government. Now, the exact charges against Ozawa are somewhat fuzzy, but they have to do with the question of whether he knew, acquiesced in, basically whether he was an aider and abettor of the 3 campaign aides who have already been convicted. Ozawa has testified at his trial that he has nothing to do with it, that he signed whatever they asked him to sign because that's why you hire, that's why you have secretaries, that's why you have people doing that kind of thing. He was busy with affairs of state. He was asked where the money came from. He said the money came from an inheritance he got from his parents. His father had also been a prominent member of the Diet, and that it came from royalties. He's written a book, for example, which has sold well over 700,000 copies, so he's made some money in royalties, and 40 years as a member of the Diet. It is interesting that it turns out that the principal piece of evidence that was relied on by the Prosecution Review Commission in deciding that Ozawa should be indicted was basically a report by one of the prosecutors concerning his interview of one of the aides who was convicted. That report indicated that the aide had implicated Ozawa and had said the reason he was implicating Ozawa basically was because as a member of the Diet with responsibilities to the public, he had to come forward and tell the truth. It turns out that that conversation did not take place. The prosecutor who put that in his report testified at the trial that his report was not false, it was simply inaccurate. Wasn't false because he didn't intend it to be false. The court has thrown out all of the depositions of that aide. The aide has since said Ozawa never told him to falsify the reports. This has brought forward a lot of press coverage saying that they expect that Ozawa will be acquitted when the court rules, which will be before the end of this month. Now, the democracy issue that we have to consider here is what is the role of 11 individuals? 11 individuals at most 22, if you had 2 prosecution review commissions, at most 22. If you look at what happened with Ozawa, Ozawa could well be prime minister today if it weren't for the actions of the Prosecution Review Commission. He might have been prime minister when Kang was first elected, and he might be prime minister today as well. And he is not, in great part, I suspect, because of the actions of the Prosecution Review Commission. And bear in mind, the Prosecution Review Commission considers complaints. So who can complain? A victim. Well, who's a victim? I guess if you were Ozawa's opponent in the election and the problem is a false financial report, you're a victim. What that means is the system is ripe for abuse by those who have been defeated in the election, or an opposition political party, or someone even within your own political party who wants to sap you of power. And bear in mind, once the Prosecution Review Commission makes its decision, you have to go forward with a trial. Since the court has rejected the depositions of this principal aide, we have suddenly seen Ozawa back in the news. There's a news report recently saying that Ozawa plans on running against Noda in the party's September presidential election. There's another news report that says Ozawa is intent upon creating his own party and taking his supporters out of the Democratic Party of Japan. Noda has been attempting to get a tax increase passed in the Diet. Ozawa has opposed it. Four Ozawa loyalists who were in sub-cabinet positions have recently resigned over this tax proposal. so that Ozawa remains a force, but a force in the background. And the question, it seems to me, that has to be considered is whether the Prosecution Review Commission procedure and the way it's organized is such that it has enormous effects on democracy in Japan by preventing, if you will, in instances, a person from being able to run for the post of Prime Minister. Bear in mind, Ozawa could not run against Noda because he'd been suspended by the party because of the action of the Prosecution Review Commission.
Thanks, Carl. Our next speaker is David Law.
Well, Bryce, first, thank you very much for the gracious introduction and for the opportunity to talk about the judicialization of politics in Taiwan. Let's see.
Oh, I'm sorry. I'll get that for you.
So there are three questions that I'm going to try to touch on today. The first, it's working beautifully, is judicialization of politics on the rise in Taiwan? Second, if so, is there some sense in which we should be concerned by the rise of judicialization? And third, which foreshadows my answer to the first two questions, why is judicialization occurring in Taiwan? So the short answer to the first question is yes, judicialization is occurring, but it depends on how you define judicialization. This is an increasingly common term in the literature. The second question, should we be concerned by judicialization? Again, the answer is yes, but the extent to which it's occurring and whether it should be of concern, again, depends on how one defines judicialization. Now, the generic definition is judicialization of politics occurs when courts decide matters of increasing importance with increasing frequency. Okay, that's the most basic definition. I think that this definition is incomplete. It is a definition of judicialization, but it isn't a definition of the type of judicialization. It doesn't identify the type of judicialization that makes people pause and wonder, gee, is this really a good idea? Right? This broad definition encompasses both behavior by courts that's entirely untroubling and behavior that perhaps might give some people pause. So my view is that there are actually four different varieties of judicialization about which we should feel differently. But the usual definition conflates all of these distinctions. Okay, so there are really two variables at work. Right? One is, can people see that along the left-hand side? One variable is the degree of legal constraint on the court's decision-making. The second is, and these are just ideas I'm trying out, so we'll see how people think of them. The second is the political significance of the decision. Right? By legally constrained, I mean, is the court deciding on the basis of relatively well-defined legal rules, and or are the questions of a type that courts routinely decide, and are the questions being decided in ways that courts usually decide them? Right? Is this business as usual for the courts in some sense? Are courts doing what courts do? The political significance, by politically significant, I mean that the survival at the highest level, the survival or legality of a regime, or even the state itself may be at stake. Right? So you take these two variables, you put them together, and you get four different possibilities. Right? So let's start with box number one, the upper left, where you have legal constrained decisions in politically insignificant cases. These are, by definition, pretty much of neither interest nor concern, right? Not really judicialization at all. Those are just run-of-the-mill cases, right? So the second scenario, these are cases that are politically significant. They are eye-catching. They have significant consequences for the regime or for the state, but they're not necessarily a source of particular concern either. So what I put in this category, for instance, the South African Constitutional Court had to decide whether to approve the 1996 Constitution based on the 1993 interim Constitution. Now, that's a big deal for any country. And yet, at the end of the day, it was a legally constrained decision in that the criteria the South African Constitutional Court was supposed to apply were laid down quite clearly in advance. They were told at the time that the country ended apartheid, here are the criteria, make sure that any permanent constitution we adopt complies with these criteria. And so at some level, it's dazzling that a court is reviewing an entire constitution, but in doing so, they are applying explicit legal criteria. I also put in this category the Chen Shui-bian cases. Now, again, these are eye-catching cases, but why do I consider the two major Chen Shui-bian cases decided by the Constitutional Court, the immunity from prosecution case, judicial interpretation 627, and the judicial assignment case, interpretation 665. Why do I put them in this politically significant but legally constrained box? Well, first, the idea of having your leaders dragged into court on corruption charges, unfortunately, it's not that unusual, right? It's the sort of thing that happens. And there's really no way for courts in such situations to avoid doing something of political significance, right? Even if the court decides to do nothing, that in and of itself is politically significant. In fact, is it really less political to let leaders off the hook when they're charged with corruption? Or isn't that just as political, but with an additional kick to the head for the rule of law, right? And third, there are somewhat standard, very standard actually, legal responses to the question of whether a president has immunity from criminal prosecution. And the answer, the fairly standard answer the Taiwanese Constitutional Court gives is yes, but only while in office, because immunity is justified on functional grounds, and the point is to enable the president to perform the performance of his duties. And if you study American constitutional law, or for that matter, Canadian constitutional law, or for that matter, German constitutional law, that's going to sound awfully familiar because it's a fairly standard approach. Here's another question the court had to consider in the Chen Shui-bian cases. Whether cases can be consolidated before a particular judge. So Chen Shui-bian, a number of things were thrown at him. The courts decided to consolidate the cases before a particular judge. And the question is, can you reassign cases to a different judge? Well, there are a couple of competing approaches. There's the German approach, which says you're not supposed to. There's the common law approach, which doesn't consider it particularly troubling. And at the end of the day, the court decided to go with the common law approach. Or pretrial detention, right? Again, eye-catching to see Chen Shui-bian in manacles holding up his handcuffs before the cameras. I am martyring myself for the cause of Taiwan. But if you think about questions like immunity, consolidation of cases, judicial administration, pretrial detention, these are inescapably highly judicial questions, right? Courts have to resolve questions about pretrial detention, and again, in the Taiwanese case, they decided to borrow a German framework. So if you look at the court's doctrinal approach, it's nothing that alarming or surprising. So even if the court rules these cases non-justiciable, that itself is a political maneuver. Just one that doesn't call attention to itself as political. So in these cases, the court, in this box, the court can't avoid behaving politically. The only question is whether they're going to resolve the case in a law-bound sort of way. And in this box, by definition, that's what the courts are doing. I will just pause here to address there was a lot, obviously, Taiwanese politics are very heated. And it's difficult to do anything in Taiwan without having one's motivations impugned as political in nature. And so the prosecution of Chen Shui-bian was not surprisingly impugned as political, and the resistance to the prosecution of Chen Shui-bian was impugned as political. And it was difficult to turn around without being accused of doing something political. And so I just want to draw attention to the fact that unusually for cases of this high profile, the Chen Shui-bian cases were decided by unanimous constitutional court. And I also want to add that a number of the justices had not just DPP sympathies. One of them in particular, Xu Zongli, was actually Chen Shui-bian's roommate and was, I can tell you, pained by this decision, but nevertheless found as a matter of law that this is the approach that was going to make sense. So the court presented a unified front. It was not a bitterly divided court of the kind we see often in these high-profile American cases. And it was the understanding, even of DPP sympathizers on the court, that this was the sort of decision that just, in some legal sense, made sense. It's also important to remember that I'm defending the integrity of the Taiwanese Constitutional Court here because I think it deserves to be defended. Now, obviously, at the popular level, there are a lot of DPP supporters who still feel that Chen Shui-bian got an unfair shake. But I think it's also important to remember that many members, when I refer to the Greens, the Green Party, the Democratic People's Party, those are all synonyms, right? So the Chen Shui-bian supporters are the Greens, the Kuomintang supporters are the Blues. It's important to remember that many Greens turned on Sun Sui-bian. At this point, most educated elites within the DPP have turned against him. For instance, the National Taiwanese University Law faculty, they don't defend him. They wanted him to step aside for Vice President Liu. They don't think the guy was run out of town by the Constitutional Court. They are pained and disappointed by him. There was essentially an uprising led in substantial part by elements of the DPP against Sun Sui-bian in the form of the so-called the Reds, or the Red Shirt Army, who were anti-corruption and called actively for the ouster of their own leader. And the Swiss at one point launched a money laundering investigation, and Sun Sui-bian admitted to sending leftover campaign money into overseas accounts, and at that point resigned completely from the party. Even if one thinks that the KMT investigation, the Kuomintang investigation, was politically motivated, it is really hard to argue that the Swiss had an axe to grind with Sun Sui-bian. Okay, so corruption is corruption is corruption. Courts faced with corruption cases have a fairly standard set of choices they can make in terms of how to deal with those cases, and the Taiwanese Constitutional Court chose from that fairly standard set of choices. So politically significant, yes. Controversial or normatively troublesome, not clear. Not clear why we should be troubled. Okay, so box 3. These are cases that are irksome, annoying in some sense, that courts aren't behaving the way that we want courts to behave or the way that we think courts should be behaving, but also kind of inconsequential in the sense that, inconsequential mainly in the sense that the court is leaving the policy status quo unchallenged, right? Those are the cases in this particular box. So, for example, so I've got a Japanese example up here. The Japanese Supreme Court's rejection of virtually all constitutional claims. For the most part, I personally find those decisions to be somewhat lawless and where the court's unwilling to enforce the Constitution. Whether they're politically significant outside of the Article 9 context, I'm not sure they are. Carl is smiling, so we may have a colloquy about this later. In the context of Taiwan, so the most recent challenge to the death penalty in Taiwan, Taiwan recently passed a statute incorporating the International Covenant on Civil and Political Rights into domestic law. And that incorporation of the ICCPR formed the basis for a new challenge to the legality of the death penalty. Now, the thing is that the death penalty is very popular in Taiwan. Okay, and so the Taiwanese Constitutional Court dismisses the challenge, saying, oh, we've considered the death penalty before and we've upheld it. And anyway, if there are problems with the death penalty, we can catch them on a case-by-case basis, which is kind of missing the point. This legal challenge has a different legal basis. And so, it's a little bit of willful conflation. We've considered the death penalty before, and so we don't need to consider the death penalty again, right? But ultimately, it's inconsequential from a political perspective because the court simply leaves things as they were before, right? It leaves the ball lying in the rough. No change. Now, box 4, okay. Here's where we have judicialization in both the... So box 2, that's judicialization in some descriptive sense. It meets the descriptive definition, but it's not judicialization in a normative troubling kind of sense. Now, box 4 is where the descriptive and the normative dimensions of judicialization, the descriptive definition and the normative concerns come together, okay? Here you have courts dealing with existential questions that go to the survival of the regime or the country itself, and these cases are being decided on the basis of criteria that the court seems to pull out of thin air. Okay, so one part of what's going on here is we're dealing with what Ron Herschel refers to as courts getting involved in megapolitics. But we're also, and this is something I don't think the literature on judicialization sufficiently recognizes, we're also dealing with cases where the court seems to be making it up as it goes along. So here's a Canadian example in honor of the 30th anniversary of the Canadian Charter of Rights and Freedoms, which is today. Right? So the Canadian Supreme Court in Ford v. Quebec had to decide, the Quebec secession reference, had to decide whether Quebec could secede, and if so, on what terms. Now, I guarantee you that if you look at the text of the Canadian Constitution, there's nothing in there that covers this problem, okay? And so the court, at least candidly, says we're going to decide this on the basis of, among other things, unwritten constitutional conventions and principles implicit in the Constitution, right? Which is judicial code, not even code, it's straightforward judicial speak for we are making this up as we go along, right? Also in this category, courts ruling on courts striking down constitutional amendments, right? So, for instance, the Indian Supreme Court got in a running fight with the Parliament over property rights, And striking down constitutional amendments is the ultimate in non-legal decision-making because you're purporting to strike down a part of the Constitution on the basis of the Constitution. I think everyone can see the logical problem there, right? Possible examples in this box from Taiwan, okay, what's interesting is that the judicialization of politics in the court has rendered a number of these major decisions that go to the survival of the regime, the survival of the nature of the state, and yet judicialization hasn't seemed particularly troubling because, in some sense, the court has done something that strikes legal elites and indeed even the general public as doing the right thing. But in doing the right thing, it has been pulling its guiding principles basically out of thin air. So, for example, in 1990, the Constitutional Court decided Interpretation 261, all right? And to understand Interpretation 261, in Interpretation 261, the Taiwanese Constitutional Court ejected the so-called old thieves from the National Assembly. Now, that requires a little bit of background here. What is the National Assembly? Who are the old thieves? So, Taiwan has Taiwan has this Rube Goldberg contraption of a constitutional scheme. Thanks a lot, Sun Yat-sen, for the most unnecessarily complicated constitutional scheme that you can imagine. I mean, even Taiwanese legal scholars are reluctant to suggest that anyone imitate this. 5 branches of government with 2 different legislative bodies structure. Okay. Plus, not to mention a provincial and federal system where the province is almost exactly coextensive with the national government. All right, so you've got a governor who has the same jurisdiction as the national government. Anyway, so the 2 legislative bodies, there is the Legislative Yuan and the National Assembly. Okay, if you can follow this distinction, the National Assembly is the embodiment of popular sovereignty, whereas the Legislative Yuan exercises the power of making laws. Right now, what that means in practice is that the Legislative Yuan behaves like a legislature, and the National Assembly is responsible for constitutional revision. Okay. Now, the National Assembly, am I belaboring background for people, or is this?
No,
I'll go with it. So, the National Assembly, the members of the National Assembly were elected at a time when the KMT at least nominally controlled all of mainland China. Okay, and they left for Taiwan. And the Taiwanese Constitutional Court, early in Taiwan's history, endorsed the theory that due to a state of emergency arising from the insurrection in various provinces, new elections could not be held to replace members of the National Assembly. Therefore, those members will continue in office until such time as the state of emergency ends. Okay, state of emergency has been running for a little while now. Right? And so the result is that the vast majority of the members of the National Assembly were unelected holdovers, and these became known as the old thieves. So at some point in the democratization, about sort of midpoint the democratization process, the Taiwanese, the KMT is led by a moderately reformist leader, Lee Dong-Hui, who's trying to gently ease the National Assembly out of office. And so the moderates in the KMT are trying to ease these guys out of the National Assembly. The National Assembly guys aren't willing to go. And it's clear there's a political consensus, even among a majority of the KMT types, that these guys have got to go. So the Taiwanese Constitutional Court finally steps in and says, all right, that's it. We're overruling that previous interpretation that says you guys can continue during the state of emergency. That's a silly fiction. Elections must be held now. And they happen to pick a date that just happens to be the exact date that Lee Dong-Hui, the president, had targeted for new elections. Not like that's pulled out of thin air or anything, but, looks pretty arbitrary, right? So the political classes, the people generally are all supportive of what the Taiwanese Constitutional Court does, but it's not getting this. There's no law, really, that it's applying in this particular case. Then the court does another mega politics decision, which is Interpretation 499, right? So the National Assembly duly gets reconstituted on the basis of elections. Surprisingly, the KMT wins the vast majority of seats in the reconstituted National Assembly. Then it then introduces a few things. First, it says, from now on, we're going to be chosen on the basis of proportional representation, proportional to the results of the election for the Legislative Yuan. And in order for this new system to go into effect smoothly, we're going to extend our own term so that it ends at the same time as the current term of the Legislative Yuan. And we're also going to have to extend the term of the Legislative Yuan by 5 months. So we're going to extend our term by a couple of years, their term by 5 months. And then when that happens, we'll have the smooth switch over to the new system. Okay, so the Taiwanese Constitutional Court looks at that and says, and remember, every time the National Assembly does this, it's doing so by amending the Constitution because only the National Assembly can amend the Constitution. So what does the Taiwanese Constitutional Court do? It strikes down the constitutional amendments adopted by the National Assembly. Again, very difficult to justify on legal grounds striking down a constitutional amendment on constitutional grounds, right? That's kind of an oxymoron. So there are examples of all four boxes, right, in Taiwan. I'm almost there. Now, and although in practice, right, these cases in box 4, oh good, laser. In practice, although Taiwan's invalidation of these constitutional revisions, Taiwan's ejection of the National Assembly members hasn't troubled observers, in principle, this is the kind of judicialization that in principle perhaps ought to give people pause. It hasn't because the Taiwanese Constitutional Court has done things that enjoy popular support. But if you think about the legal underpinnings for what the court's doing, questionable. Okay, so why are we seeing judicialization in Taiwan? So we'll go from micro to macro explanations, right? So here's a micro explanation. The tons of constitutional revisions in Taiwan. One of the ones that people have pointed to is the introduction of term limits for justices, a one-term limit. The argument here is that is enhanced judicial independence. Justices will have to worry about currying favor with the regime, so they'll be renewed. That should embolden them to take on big issues. This may be a factor, but if so, I personally doubt that it's a big one. And in reality, term limits for justices hasn't prevented the government from going after the Taiwanese Constitutional Court when it's been unhappy with the court's decisions. For example, the retirement benefits for justices were significantly cut, other than the ones for the career judges who were towing the government line. So it's not clear that the court's independence is enhanced greatly. But anyway, I throw that out there. So second, democratization demands some kind of coordinating mechanism. And in periods of democratization, moreover, there's no obvious alternative to the Constitutional Court. So think about the basic question that constitutional law answers, right? Which is, who gets to do what? Who has what power? Constitutional law is supposed to govern the allocation of public power. Who can do what, under what conditions, subject to what limits? Now, think also that the allocation of public power generally has to be self-enforcing because there's no one around to enforce the Constitution against the government, right? Constitutional courts don't actually enforce the Constitution. They announce constitutional decisions. They don't have the power of the purse of the sword to back up those decisions. So if the system works, it is the result of coordination, not enforcement. Okay. Now, there are three ways to achieve coordination on a system of political arrangements, right? One is well-defined expectations based on past experience. We do what we've done in the past. That's worked well for the British. They haven't needed a one-shop stopping kind of formal constitution because they have hundreds of years, centuries, even millennia of experience to draw on. So they pretty much know how things are done by consulting past experience. It's the whole idea behind the common law, indeed. Second way is you coordinate on rules, right? You have X power, you have Y power, you have Z power. You set that forth in a constitution. That's another possible way of coordinating. But then what happens if you don't agree on what the Constitution means? So then you have as a fallback the third possibility, which is you coordinate on some kind of a referee, right, which is the Constitutional Court. Rather than coordinating on a particular rule, we all do X, we all do Y, we coordinate on a particular referee. We all listen to X. We all listen to Y. Now, you are a new country, you have a new constitution. These are exactly the circumstances under which, first, you don't have past experience to fall back on. Second, the meaning of the Constitution is least clear, right? You're talking about a new document that hasn't been interpreted very much. And so it is precisely under these conditions that you most need courts as a coordinating mechanism. Okay? Answers to questions about who has what power are by definition unclear in transitional situations, such as the transition to democratization. The regime is new, there's no body of expectations or experience to fall back on, just as we saw in both Taiwan and South Korea in the late 1980s. Last explanation, which hopefully will be very intuitive, is simply politically gridlock. So Taiwan is closely divided politically. As we know, political division, political gridlock, creates both the need and the opportunity for courts to engage in policy making. Now, first, when you have political gridlock, who else is going to make policy, right? If there are some big questions and there's no political majority capable of putting its will into action, someone's going to have to make the call. And when other political forces are gridlocked, that creates a vacuum, both the need and the opportunity for some other institution to step in. The idea that nature abhors a vacuum applies perfectly well to government. And courts can't resist a determined policy-making majority over the long run. American experience will show either they surrender or they're overrun. Last paragraph.
Okay.
But conversely, when politics are deadlocked, courts have an opening. Now, political scientists have illustrated this intuition that under conditions of gridlock, they use these very simple unidimensional models of policy-making gridlock to illustrate that the more gridlock there is, the further apart the other political actors are, and the more room, in both a literal and metaphorical sense, courts have to make policy. Right? In conditions of gridlock, what courts do to make policy is they find two veto players, two political actors with the ability to veto policy changes, and they pick a point somewhere in between. And whatever point they pick in between is going to stick, because if anyone tries to move it, one of these veto players is going to veto the change, right? So you have democratization, which arguably brings the Taiwanese Constitutional Court up to what's called high equilibrium judicial review, and then it stays there because of political gridlock, the closely fought political battle between the DPP and the KMT. So I hope that's at least given people food for thought. I don't know if it's fully baked, but hopefully it's worth thinking about. Thank you.
Very good. Our next speaker is Jonathan Kang.
Thank you. I'm wondering, do you think I could sit there for while I...
Okay, sure.
Sorry, Carl. Can I swap with you for a minute while...
Yeah, why don't you stay here?
I think it would be too much of a challenge. I'd be rubbernecking while trying to speak, so...
Is yours here? Oh, that's not it. I think I may have loaded the wrong one. Do you have the... Okay.
Now I see why we need a backup. Good idea.
Oops.
It just kind of has to lock in place a little.
Oh dear.
I love Windows. That's why I use a Mac.
There we go.
Okay.
Cheap shot.
All right. Well, thank you very much for your patience while we're setting up, and thank you to Bryce for inviting, and the Center for inviting me and my two colleagues, and also for the very generous introduction. And in Asia, when I speak in Asia, people mention where I went to school all the time. In the U.S., thankfully, it doesn't happen that much, but it did happen today, so for that, I apologize. And so today I want to talk about judicialization as well, but in the Korean context. And the privilege of going last is I can piggyback off of what my colleagues have said and hopefully zip a little more briskly through the presentation. So a little bit of background. I don't know how much is necessary. I wasn't sure how much people knew about Korea and the Korean Constitutional Court. But the courts was established post-democratization after the big democratization in 1987. Court was established in 88. It's generally considered to have been played a very positive role. Is considered to be a critical contributor in democratic consolidation. In terms of kind of structures, very briefly, there are 9 justices. They serve 6-year terms. They're renewable, but that's only actually happened in one case. They've got this triumvirate appointment system, is very similar to the French model. Everyone's formally appointed by the president, but 3 each are nominated by each branch of the government. The executive nominates 3, National Assembly nominates 3, and the Chief Justice of the Supreme Court nominates 3. It's got a supermajority decision-making rule. So 5-4 decisions means that the statute or the case or the executive action remains in place. You need a 6-3 majority to hold that a statute is, for example, unconstitutional. It also has, following the German model, from which it borrows fairly heavily, it's got this non-binary decision-making matrix. So just like we'd think of in the U.S. and many other contexts, certainly you can find that a statute or governmental action is constitutional or unconstitutional, but you can also find it non-conforming, meaning you haven't quite done what we would like you to do, and so we'll give you a couple of years to fix it, but we'll leave this law in place. Right, and the court's done that number of occasions. Right, it's a situation where you're sending a signal to the legislature, "Hey, fix this problem. If you don't by the deadline that we set for you, then there will be further consequences." They've also, and we do similar things in the U.S. too. They've also found statutes, for example, unconstitutional as applied in this case, or potentially constitutional, but only if interpreted in this specific way, and we're going to articulate how. Right? It is perhaps the most well-respected and well-established constitutional court in Asia. It's the head right now is the president of a new body, the Association of Asian Constitutional Courts and Equivalent Institutions. It's the AACCEI. I think they have a website. You've got Korea, Indonesia, Thailand, Mongolia, Uzbekistan, Turkey, Russia just became a member, and so on. It's an expanding body. I have some data. I mean, this is kind of try to back up some of what I've said. This is current as of March 31st of this year. So since the establishment of the court, as of last month, you've had 22,000 cases filed. And if you look at the kind of situations in which they've struck down official action or statutes, it's actually a very high number. If you contrast it to Japan, where almost nothing has ever happened, that's the easy contrast. But even compared to many other jurisdictions, including our own, the number of occasions in which the court has found a statute, let's say, unconstitutional or unconformable, this is I'm using their terminology from the official records of the Constitutional Court, which I find a little bit misleading, but it is what it is. That's what I called nonconformity. Like, you fix it, but we'll give you a timeline. I'll leave it in place. Unconstitutional, unconformable, unconstitutional in various contexts, and so on. I mean, you've got a very high number, approaching 700 cases. And the bulk of the court's docket, as you'll see, has to do with constitutional complaints. Now, those are direct complaints that could be filed by any member of any citizen or any resident challenging official action or a judicial decision at any time once you've either exhausted remedies, gone through a legal proceeding or administrative proceeding and no one's listened to you, or if you've requested in an administrative or judicial proceeding that to refer a case to the Constitutional Court, and that request has been denied. So the 5 areas in which the court exercises jurisdiction are constitutionality of laws. That's when you get cases referred by the ordinary courts. Impeachment, of which there has only ever been one case, and I'm going to spend some time talking about that in a minute. Deciding on the dissolution of a political party, that's never happened. Competence disputes are basically jurisdictional disputes either between executive branch agencies of the central government or between local government and central government, and there's been a bunch of those. But the bulk of the filed cases are constitutional complaints, and obviously it's been used quite liberally over the years. Now, kind of going off of what some of my colleagues have already said, what on earth is judicialization, and do we need to be worried about it? The name that comes up most often in the literature, even though he's not the only person, of course, to have started talking about this, is Rand Herschel of the University of Toronto. And he says, well, there are 3 interrelated processes, all of which I don't like and I'm worried about, but I'm especially worried about number 3, right? So he says, well, what's judicialization? Well, first he says, well, there's a spread of legal discourse everywhere, legal jargon, legal rules, lawyers, law professors, and so on, right? We know all about that here in the U.S. too. Number two, there's the expansion of the province of courts and judges in determining public policy outcomes. That's a little bit vague, but I'll leave that there for now. What's really important to Herschel and to others who are worried about judicialization is number three, what David Law also referred to, megapolitics, basically. He says when courts are the avenue, instead of other branches of government or other mechanisms, for deciding core political controversies that can define entire political eras or parties and so on, right? So he says, well, this is really troublesome because we're all worried about the counter-majoritarian problem of judicial review, and the democratic credentials, the legitimacy of judicial review is most troublesome when you have judicialization of these watershed national questions, very high political stakes with almost no legal guidelines, right? Box number 4 in David's matrix, right? That's what he says, that this is what we're worried about. And Herschel says, well, what happens in that situation? Well, you have avenues for things like what he calls hegemonic preservation, right? He says there's evidence, he goes through a number of different jurisdictions to make this case, that the judges and elites use the rhetoric of rights. He's one of these people who hates rights talk and so on. People who use the rhetoric of rights, legal jargon, and judicial review to bolster their own position, to preserve their own position in the polity when it's being threatened by other forces. So basically using the courts in a counter-democratic, anti-democratic way, right? So if that's really what's going on, maybe that is quite troublesome. Now, Herschel himself does talk about Korea, and other scholars do too. When people talk about judicialization in Korea, they mainly talk about two big cases, both of which occurred in the same year, 2004. So I'll focus on those, right? The ones, these are arguably, clearly in box number 4, according to the critics, right? Using, again, referring again to David's matrix and Herschel's work. So the first case is impeachment of former President Roh Moo-hyun. And the second case is the proposed relocation of the capital city out of Seoul, right, to the center of the country. So I'll start with the Roh Moo-hyun case. This was a controversy that arose in the leading up to the National Assembly elections of 2004. Roh Moo-hyun had been in a precarious political position in a number of ways at that time. And among other things, he made statements in support of his own political party and critical of the ruling Grand National Party at the time, which had a dominant position in the assembly. He'd sought a national referendum, kind of daring the voters to challenge, his position, being confident that he would survive such a confidence vote. In effect, there had been bribery and corruption allegations, as there always are, and there had been accusations that he was just running the country to the ground by pure misadministration. So the National Assembly conducted a vote, and 193 out of the then 272 members of the National Assembly voted in favor of a motion for impeachment. The 47 members of President No's own party, the URI party, boycotted the vote, but they wouldn't have changed the outcome. You need a 2/3 vote, and they far exceeded that number. And they made detailed factual findings in an extensive report in all these 5 categories, alleging violations of law. Now, the Constitutional Court under the Korean system, in our system, obviously the Senate sits as a court almost in impeachment, but in the Korean system, once a National Assembly passes a motion for impeachment requiring a 2/3 majority, then the Constitutional Court has review authority, right? And this case was duly referred to the Constitutional Court in accordance with the Constitution. The court found that, yes, No had committed, well, certainly the first 3 violations, but also then it did a proportionality analysis and said while we agree that these violations occurred, they didn't rise to the level to justify removal from office, right? So they articulated a standard. They said, well, it's only when there's been serious damage to the free and democratic basic order of the country, and that damage is so grave that we can only fix it by removing the president or the executive branch official in question from office will we exercise this power, right? And they discounted most of the allegations under Category 4, the bribery and illegal campaign fundraising allegations, by saying impeachment claims can only be brought with respect to conduct while in office. And the alleged illegal campaign financing occurred before he became president. So this is outside of our scope, they said. And they rejected the claims for misadministration on the grounds that, well, these are political, right? They're not, we don't assess political conduct or efficiency or how well you do while you're in office. That's for other branches. We just look at violations of law. We find that the president has violated the election laws, has improperly sought a national referendum, and has shown contempt for the Constitution by challenging the ruling of the National Election Commission that he has violated the election laws. So I think it's important to see, what the court does and doesn't do. It certainly, explicitly, clearly found that the president had violated a number of different laws. But it also, as courts often do, and as any political branch of government does, it established and claimed some more authority for itself vis-a-vis other branches of government. The National Assembly, in its briefs in this case, had argued that the court should only play a procedural role, right? That we make all the underlying findings, and you just decide whether the National Assembly has followed proper procedure in impeaching the president or not. Right, so you're just reviewing to see if we've dotted the I's and crossed the T's. The court rejected that. They said, well, we'll review everything you do de novo, right? And we'll make additional factual findings if we need to. We won't defer to any of your findings if we find that it's inappropriate, and it went ahead and ended just that, right? And so while it affirmed most of the findings of the National Assembly, it said, well, we're doing this under our own authority, not because we owe the Assembly any deference on these issues. So this sounds like, well, a terrible case of category number 4. I mean, part of it is, the standards for impeachment are not clear and not explicitly stated at all in the Constitution, right? This obviously has to do with, as high stakes a political issue as you can see, right? So this kind of thing should be terribly, terribly troubling for people who don't like the judicialization of politics, right? So should we be troubled about this case or not, right? I mean, part of it depends on, what's the kind of judicialization that really worries us? The court, in its decision-making, tried to continually emphasize we're only doing legal decision-making. We're not making political decisions, right? So deciding on whether the president has been a good administrator, that's a political judgment. We're not making those judgments. We're just deciding, did he violate the election laws? Did he show respect for the Constitution? Did he properly exercise or not exercise his power to call a referendum under the Constitution, and so on, right? So we're just doing political things. We don't want to do legal things, sorry. We're not trying to overstep our authority and go into the area of pure politics. Obviously, the counter-argument to that is, the courts are, in many cases, inevitably political actors, right? So how do we feel about that, right? I mean, what's the court's role during normal politics times, to use a term of Bruce Ackerman's, right? What should the court ideally be doing, right? Now, while this impeachment case can be very troubling, if you think about the fact that the stakes were high and the decision-making appears to be very unconstrained, I think there's a very strong argument that is actually not so worrisome, right? And here's why, right? The public opinion at the time was very, very strongly against the National Assembly for its finding of impeachment, right? I mean, depending on which opinion polls you believe, the public was somewhere upwards of 70%, perhaps close to 90+% against the National Assembly's decision to impeach, right? Now, after the impeachment decision was made, but before the Constitutional Court rendered its decision, the general election occurred, right? And in the general election, the opposition Uri Party, the party of the impeached President Roh Moo-hyun, for the first time won a majority of seats in the National Assembly, winning 152 out of 299 seats. That's an overwhelming victory for them because they started off with 47 seats. I mean, that's a huge uptick in terms of the number of seats they were able to gain. And so if you look at it in that context, and the court reacting to that election victory, I mean, there's no evidence that they explicitly looked at that, but how could you not have? it was the big watershed political change in the country. They found that the President No had not done enough to warrant impeachment. A lot of commentators then looked at this and said, well, they're actually being very reactive and cautious. They're doing their judicial decision making in a way that's very cognizant of democratic forces and popular opinion, right? One commentator writing about both this case and the Chen Shui-bian case says these two decisions are masterpieces in creating win-win situations. That there was something for everybody, and both courts acted very strategically and politically in Taiwan and Korea in trying to be sensitive to how public opinion had shifted, right? And just like David described with respect to Taiwan, in the Korean decision also they decided to speak with one unanimous opinion, which is somewhat unusual, both in Korea and, of course, here in the U.S. In fact, they spent the last 2 pages of their opinion explaining why it was really, really important in impeachment cases to have no concurring or dissenting opinions, to speak as one voice, given the nature of the kind of question that we have, right? So if you look at it in this regard, if the main thing we're worried about in these situations of high political stakes, unconstrained legal reasoning, is that courts are not going to be responsive to public opinion, in this particular situation, arguably, they were trying to be very responsive as they could, given that the case was put into their bailiwick to public opinion, right, by going along with the popular democratic sentiment expressed through the general election, right? If we take that into account, then, how much judicialization is there? Should we really be worried about it? And where is it coming from, right? There's different commentators and in different disciplines who talk about judicialization in Korea and describe it as both coming from above and from below, right? In very, very quickly, why might it be from above through elites? In other words, well, the Constitutional Court's authority is explicitly carved out in the structure of Korea's government. There's a theory, well-known theory of political insurance, that the elites were worried about what would happen after democratic transition, and they wanted to empower the courts in such a way that they'd serve as a brake towards too much and too rapid a growth of purely progressive or leftist sentiment. It's a theory that's generally identified with Tom Ginsburg of the University of Chicago. In terms of from below, there's a huge amount of popular support for the Constitutional Court. I mean, I've already looked at the numbers in terms of constitutional complaints. There have been a series of surveys conducted annually by 2 news agencies and a well-regarded nonprofit think tank that has always ranked by a pretty huge margin the Constitutional Court as by far the most trusted public institution in Korea, above all the other public institutions, some by significant margin. And there is very, very favorable press coverage about the jurisprudence of the court on many issues, such as affirmation of basic rights, the repealing of some of the harshness of the National Security Act, retroactive justice vis-a-vis some of the actions of the military governments before democratization, and so on, right? So if I look at it in this context, perhaps the case that should be really troubling to us is the relocation of the capital city from Seoul. So part of Roh Moo-hyun's campaign platform when he was elected was that he would move power, political and economic power, away from where it had been concentrated in Seoul and to the provinces. A linchpin of his election platform was that I'm going to move the capital. Right, and so the National Assembly duly passed an act, and the court, by an 8-1 margin, found it unconstitutional. And they found it unconstitutional because they said that, well, Seoul had been the capital for over 600 years, and the customary constitution requires that it must be maintained as the capital unless you have a constitutional amendment. Now, there's no such thing as a textual customary constitution. There's nothing in the constitution that says the capital shall be in Seoul. The idea of a customary constitution had never been invoked in Korean constitutional jurisprudence before. So this is like a textbook case of big political stakes with completely no constraint on decision making. And they invent a doctrine, a class of doctrines for the first time, and decide that the National Assembly's Act is unconstitutional, right? But then what happens? There's tremendous negative reaction to this. The court is seriously criticized for having taken this leap towards the customary constitution. And there's a political reaction. The legislature submits an alternative plan to move that's arguably very, very similar to the original plan, but different in a couple of respects. It doesn't move the Supreme Court, National Assembly, Ministry of Foreign Affairs, but the economic impact is as large. And the court unanimously ruled, less than 1 year after this original case, that the act was constitutional. And it never, ever has referred to this idea of a customary constitution again, right? So the initial capital city case might have been troubling, and again, that could be one of these textbook examples of judicialization that we all might not like to see, but the court arguably corrected itself. It realized we've gone too far, public opinion is not with us anymore. They basically did a mea culpa, implicitly, and ruled in the opposite way less than 1 year later, and it abandoned the line of jurisprudence that led them to find that the capital had to be maintained in Seoul. So if I look at it from this perspective, I see a lot of judicial decision-making for high-stakes political issues in Korea, but maybe in a way that's ultimately not terribly troubling, right? A lot of people have said that the courts in Korea, the Constitutional Court in Korea, has acted as a democratic consolidator that has played a huge role unexpectedly. No one had thought that it would be so important in 1987, but in 2012, a lot of academics and observers say that, and I'm among them, the court has ended up playing a really important role in helping to consolidate democracy, and has tried to be very responsive to public opinion where possible, right? It's not trying to be at the forefront and pushing political transition, but it sees itself as playing an instrumental role, trying to be reactive to how social forces and political sentiment has shifted, right? And what's helped it to do that, among other things, are the supermajority rule and the non-binary forms of decision-making, things that people have proposed as reforms in other jurisdictions to help reduce the incidence of megapolitics in the courts. But they're institutional reforms that have always existed in the Korean model. What might happen in the future? I mean, there's going to be more issues. There's constitutional complaints pending now arguing that the Korea-U.S. Free Trade Agreement is unconstitutional on a number of different levels. There was a general election last week in Korea where the ruling party maintained a slim majority in a huge upset of 152 seats out of 300. If they had lost, it would almost be certain that there would be a big political brouhaha over pulling out of the Korea-U.S. Free Trade Agreement. And now that political fight has been somewhat averted because the ruling party stayed in power, again, you're going to have this fight in the courts because the courts will have to decide on the constitutionality of the free trade agreement. So these types of conflicts will continue, but based on the evidence we've seen so far, the courts either not overstepped its bounds in the first place at all or try to be reactive to public opinion as much as it can, and not in a way that's overly troubling as of yet. Thank you.
Okay. I'm going to ask the first question. I'm going to invoke my right as chair, I guess, and then we'll open it to the floor. And my first question, I think, goes to David, really, but it's about Carl's presentation on Ozawa. And Carl might want to weigh in here as well as Jonathan. Does the Ozawa case constitute, according to your model, judicialization? In that, I mean, as far as I understand, you have to have two criteria, right? You have to have the courts have to be legally unconstrained, and it has to be a huge political case. It certainly is the latter of those two, meets the latter of those two criteria. But my understanding of the Ozawa case is that the courts here seem to be pretty much bound to take this case if there is a complaint laid. What are your thoughts on that?
It doesn't sound like the Japanese courts have a way out of deciding the case, and corruption cases are corruption cases, right? Those are the sorts of disputes that courts decide. If courts don't decide corruption charges, who's going to decide them. So you have something that courts normally do, and they're doing it in what seems like a very rule-bound way. It certainly doesn't help that the Japanese judiciary has an excellent reputation for probity, right? You don't hear Japanese judges being bribed. I mean, any number of complaints have been leveled against them, but dishonesty and corruption aren't among them, generally speaking. So that combined with the Japanese judiciary's general unwillingness to do anything that might provoke a political backlash, I think puts the judiciary on fairly solid ground. But I don't think that, I think that this is a case of, if I'm going to attach labels to that typology, if you can imagine the typologies up there again, in that box where the decision, the upper right box where the decision is legally constrained, is politically significant but legally constrained, that's high stakes adjudication in a literal sense, right? As opposed to mundane adjudication, which is politically insignificant and legally constrained. So there's nothing you can do if you're a court and you're faced with a high stakes case. There's really nothing you can. You only have two choices, right? You can either A, decide it. It's a high stakes case. Nothing you do is going to make it a less high stakes case. That's just the hand you're dealt. Or you can actually try to shift it down to that other box, which isn't up there. You can try to shift it down to the legally unconstrained but politically insignificant box. Right, that is sort of what Alexander Bickel would tell the Supreme Court to do: exercise the passive virtues. And so, can I borrow the pointer? Thank you. If this is a game of judicial snakes and ladders, right, the one move you can try to make in this game is, so on the left-hand side, the courts are never getting into trouble, right? There's no institutional threat to the court. When you're on the right-hand side, even if you're doing things that are legally constrained, you still might get criticism, as the Taiwanese courts got in the Chen Shui-bian cases, as the Japanese courts are getting in the Ozawa cases. And so you have two choices. You can either live with it, suck it up, and do your job, or you can try to play this game of the judicial snake where you slide from box 2 down to box 3, right? Where you go from high-stakes adjudication to judicial abdication. Those are your only options. Decide the case or weasel out of it, but if you weasel out of it, you're weaseling out of your legal responsibility. So I don't think the Ozawa case is an example of judicialization. Is it okay if I follow up on a point that Jonathan made? In terms of, Jonathan made an excellent point, which is one that I should have made, but I want to amplify it, which is why judicialization in Korea and in Japan, right? And this idea that there's really no place, who else is going to play the role of deciding who else is going to decide these kinds of disputes, right? On the one hand, if you think of all the institutions that could resolve these power disputes, courts are in some sense the lesser of evils, right? They don't have the power of the purse, they don't have the power of the sword, they hopefully have the least to gain by behaving in rent-seeking ways, right? They don't get campaign contributions. They generally don't get involved in shady land deals. So of all the choices out there, they're the least unsavory choice. And that is reflected in, Jonathan alluded to the public opinion polls showing strong support for the Korean Constitutional Court. This is a robust cross-country findings. Anytime you stack the courts up against other public or even private institutions, the courts come out smelling like a rose, whether it's Canada, Germany, Japan, India, the United States, whether they're courts with a reputation for activism or courts with a reputation for passivity. You give people the choice, and both out of necessity and out of choice. If someone has to make up the rules in the equivalent of the sort of Wild West frontier environment of democratization, people are generally going to want the courts to do it. There's something magical about courts that people like.
Okay. Right. If I can give you a second bite at the cherry, perhaps you could perhaps outline a case where there is that does.
Well, before going to that, I would like to say I agree with David that the Ozawa case, the way it comes up, is not a question of judicialization. But I think the more fundamental question is whether the amendment to the Prosecution Review Commission law is a case of judicialization. Because what you've done with the amendment of the law is you've taken out of the formula of normal criminal law cases the aspect of prosecutorial discretion. And what you've done is you've placed in the hands of a complaining party who may have an axe to grind the ability to present to lay people who have neither a structural system that they can rely on or some sort of historic knowledge of what factors you should consider in rendering a decision to indict or not indict, the possibility of dramatically changing and therefore having an enormously politically significant effect by putting a matter into the courts. And in a sense, that's a kind of judicialization. So while the courts are not involved in the judicialization, the statute is involved in creating a judicialization. Now, that may be somewhat different than the judicialization talked about in the papers you were discussing, but it is a form of judicialization, I would suggest.
I'd wanted to sort of pose a question, to both of you, and mainly to David, but I ran out of time because I was too focused on my own presentation. But I'm wondering, looking at the, how we've categorized, how David's categorized this, like whether what's just as, or maybe even more important in some ways, is another element in terms of, whether this is the kind of thing that the court should be deciding, because there's instances I can think of where the court's decision is legally unconstrained and it's high political stakes or low political stakes, but we're not troubled. We're not troubled because we know that this is the kind of question that needs to be resolved by the courts, right? And in Korea, there's cases where this kind of thing happens. In the process of reforming the criminal procedure laws, the level of actual constraint the Constitution gave to the courts, very questionable, but everyone supported what the court was doing because they understood, well, this is the kind of thing that the Constitutional Court is there to do, right? The level of actual legal doctrinal constraint from constitutional text or other precedents or other statutes is very low, but this is a job for the courts, right? And then there's other jobs where we just don't think even the court should be deciding this type of issue, right? I mean, if I have a U.S. example, so the executive, has criticized both Citizens United and, the pending healthcare reform case, right? And that's come up. But the criticisms that have been raised in the statements made by the president and others are different. People in the Democratic administration, don't like Citizens United, but I think most people agree, defining the parameters of Citizens United, that's the job that the Supreme Court is there to do. In this country or in any other country. Whereas some of the people who criticize the pending healthcare reform case, they're speaking from a position where they're saying the court shouldn't be deciding this, right? We've already passed this act. The court shouldn't be deciding this anymore. That's what people were saying about the capital relocation case, for example, in Korea, right? Well, courts shouldn't be deciding this, right? This was a big campaign issue. They passed a statute after a serious debate struggle, in the National Assembly, shades of the Health Care Act, and while the court shouldn't be deciding ultimately whether this law stays in force or not. And that's a situation where I think some of the sentiments against judicialization become very, very strong. In some situations, even though you have very little legal constraint, people are okay with the courts deciding it because that's the job of the courts.
Jonathan?
David first,
so
and then Cal.
I think it's absolutely right. I'll try to do this without shooting Bryce in the head with a laser. I think it's absolutely right that just because you're in the lower half of the box, right, doesn't mean that people are troubled by what the courts are doing. Maybe they should be, maybe they shouldn't be, but I think it's possible to articulate the kinds of criteria that determine whether people are or should be troubled. So, here's to sort of try to pull together what Jonathan's saying, I think, into a succinct principle. If on the one hand some kind of decision is necessary, or inescapable, on the other hand, a legal basis for making that decision is unavailable, right? So if somebody's got to make a decision, but there's no way of making it in a law-bound way, then you have to excuse being in this box because there's just no alternative, right? Here's another condition under which being in this box might not trouble people, which is when the court is effectively articulating or building some kind of a consensus or doing something that everyone agrees on the merits is reasonable, right? So I would say possibly the Canadian Quebec secession reference falls in this category. Sure, the Canadian Supreme Court was making it up, but what did they make up? They said, okay, you have to talk to each other. Oh, okay. So, I mean, yes, that was pulled out of thin air, but how are you really going to object to the idea that you have to talk to them if they want to leave, and you have to promise not to try to kill them, right? So, no better alternative out there to the court. Decision is necessary, but no legal basis for decision is available, and or the decision itself builds or articulates consensus. I think under those conditions, right, you can be in this bottom half and not arouse normative criticism, at least.
Carl, did you have something?
I was going to say that I think in Japan the shoe is on the other foot, in the sense that while the public doesn't seem to get terribly excited about what the Supreme Court's doing, the fact is there's a large group in the legal profession that is quite concerned about what the court is doing, in the sense that the court isn't doing what it should be doing. As David pointed out, when you look in that politically insignificant, legally uncontested box down at the bottom, the Japanese Supreme Court has rejected virtually all constitutional claims. And there is a movement in Japan amongst Japanese legal professionals to amend the Constitution to create a German-style constitutional court, on the theory that if they do that, then maybe, in fact, these constitutional questions will get decided rather than not decided, so that some of the individual rights that are contained in the Constitution will actually be brought forth as rights. Now, there are people who object to that for various reasons. I happen to be one who does object to that, because I don't think it's the institution that's the problem. I think it's the justices who are the problem. And unless you change, perhaps if you change the institution, you change the method by which the justices get appointed, therefore you might get different justices, but you shouldn't be going around the barn. If the problem is the justices, you ought to deal with the justices. But there is some shoe on the other foot, so to speak, in Japan because of inaction by the court. And that's why I mentioned the election law and the fact that these restrictions on free speech rights have been upheld uniformly by the Supreme Court of Japan in the election context on the ground that they're leveling the playing field. But when you look at a candidate who is a party candidate running in a single-seat district, but also put on the rolls of the party for the proportional representation, he's not on an even playing field. He's much further ahead than the independent, and yet the court has upheld that. Never mind, we're supposed to be leveling the playing field.
Okay, great. I'll open the mic to questions. Helen, if you could just wait for Joshua to come with the microphone.
换汤不换药, you know that saying? The broth and not the medicine.
Standard rules apply, Helen. Identify yourself.
Helen Rafael with Resources for the Future, and I do have a JD, a law degree. So I've been through the barrage of law teachers. I was going to disagree. Well, first of all, I want to thank you for these fascinating and illuminating illustrations of the constant tug of war between the judicial and the legislative or administrative parts of government. And I was going to ask you to apply this to the United States system, but the question I was going to ask about was in disagreement with your statement that the courts always come out smelling like a rose. I don't think that's true, and I think that Professor Kang, with his Citizens United, and I don't know what's going to happen with Obamacare and so forth, really worry me, and I hope that those can get pushed in the direction that I would like. But since that question really, unless you want to talk about the United States system some more than Professor Kang already brought up. Let me ask you about the international legal system, the International Court of Justice and the International Criminal Court. What is the significance of the formation, fairly recent formation, of those two courts of the international court system, and how do you expect it to evolve in the future?
Just quickly, Helen, could you substantiate your claim, I guess, that the courts don't always come out smelling like roses? I mean, are there any cases that you know of that where this is?
Did I say that they always come out? I think it was one of these scenarios, right?
Oh, okay.
I think it was only. It's not in every one of these scenarios the courts come out looking fine.
Well, would you talking to the microphone?
I don't. I'm trying to remember exactly the context in which I used those words. It's not. I don't have a script in front of me, but I don't think I would have. I would not argue that in all four of these situations, courts come out smelling like a rose. I would not argue that at all.
Okay. You seem to have, somehow you gave me the impression that you felt that the
courts they definitely
thought more highly of than the legislature.
They can come out looking very badly in this situation. But even in this scenario, there are things that courts can do to not come out looking that badly, but they can look very bad in this box.
If my recollection of it is, and this is a point on which I think I was agreeing with David, I think that one of the things we were both saying was certainly in Taiwan and Korea and in, I think, a significant number of other countries, if the question is posed, here's this troublesome issue, which branch of government would you like to decide it? And most of the time, the courts are up there in terms of we have faith that they're more likely to come up with the right decision. Now, can it be that we think that, but we disagree with the decision, i.e., I think they should decide it, but I hate Citizens United, right? Yes, you can, right? But that's a different from the ex-ante question of which institution do I have faith is most likely to do a good job. And in many of these East Asian transitional economies, countries, there's not a lot of the least faith-inspiring is the National Assembly, right, or the legislative body. A little better, so this is Korean and Taiwanese context as far as I know, is the executive, but much better than either of these tends to be the courts, except if they pull a relocation of capital or Citizens United or some other case that I don't like, right?
The trouble is that unless there's a 4-year or 6-year term or whatever it is for the justices, the courts last so much longer than the assembly or the president. You can kick them out of office within a few years or change the system that way, but the courts seem to drag on for a much longer time, the court decisions.
Well, I wanted to focus on the international aspect that you asked, but not the two courts you were talking about. And that is, I think the issue you raise has come up in connection with the European Court of Human Rights. And that court has attempted, I think, to deal with this judicialization question by recognizing that the members of the treaty that brings the court into existence and whose jurisdiction is defined by the treaty, those members may have different opinions about questions. And so the court attempts, in some cases, to avoid getting involved by saying, well, there really isn't a consensus amongst the members of the treaty, and therefore we can't say this is a violation of the treaty at this point in time, leaving themselves the opportunity to change the opinion in the future. Nonetheless, it does get itself involved in some interesting questions where it decides constitutional questions for member countries. For example, the German Constitutional Court has put a relatively high priority on free speech rights. And so in the Princess Caroline cases involving photographs of Princess Caroline of Monaco with her children and her husband and so on, the Supreme Court, the Constitutional Court in Germany has said, well, some photographs shouldn't have been published, but the other photographs, it's all right to have them published. Princess Caroline took that to the European Court of Human Rights. The European Court of Human Rights presented a higher priority on privacy rights and a lower priority on free speech rights. And that, I think, may be viewed by some as a question of judicialization. Both rights are provided for in the treaty, and after all, Germany has a constitution, and it has certain rights in the Constitution, and that now has created a debate, at least in Germany, over the question of who decides what the German Constitution means. Is it the Constitutional Court, or is it the European Court of Human Rights? And they were presented with that question in the second Princess Caroline case, in which some different photographs were involved, and in which they upheld the free speech rights of the press in printing the photographs. And Princess Caroline, of course, went back to the European Court of Human Rights and said they're not applying your decision correctly. So I think you get into this question of judicialization not just at the domestic level, but you can get it in the international level as well.
Great. Any more questions? Yes.
Hi, I'm Janice Chen from the Formosan Association for Public Affairs, and I do also have a JD. And I'm kind of fascinated and at the same time a little bit puzzled by this concept of judicialization just at a basic level, because I hadn't encountered it before. And I think, usually when we think about politics in the judiciary, we think of it in terms of the more traditional ways, thinking of the politicization of the judiciary and just thinking of sort of in having an independent judiciary and sort of basic rule of law issues. So I think I find that it is very useful and analytically when you, especially the grid, where you're thinking about legally constrained versus unconstrained and deciding questions that are politically significant. And in the Taiwan case specifically, the National Assembly example is where you really see where that plays out. But where it's applied to the Chen Shui-bian case, which is another one of the really high-profile examples for Taiwan, my understanding is that a lot of the objections to the way that the case is played out is not so much directed at the decisions by the Constitutional Court, which I think, is considered to have a high degree of judicial independence, but a lot of the suggestions that the prosecution has been politically motivated is focused more at what happened at the trial court level in prosecutorial misconduct, or the intimidation of the defense attorneys, or the way that the witnesses are called and questioned and so forth. So I just wonder if that's one place where you could see that the concept is maybe limited in the sense that it doesn't capture the full range of concerns about that we have, where we see politics in the judiciary mixing, or is it just that I'm not sort of valuing the sort of normative concerns about judicialization as a concept in general? So it's a little more of a comment than a question, but maybe you can respond to that difference.
I think that, and I think it's tempting to apply the word judicialization willy-nilly to the point where, we end up using it the way we use the word legitimacy, or the way the Smurfs use the word Smurf. And in meaning all things to all people, it ends up meaning nothing to anyone. And so I'm a little hesitant with regarding some of Carl's applications of the term judicialization. But I think that, it's my fault, really, for not thinking more about what happened at the trial court level in Taiwan. It is very hard. From a distance, what I take away from it is everyone was so unhappy on both sides with everything the trial court did That, it's like when everyone hates you, you must be doing something right? If the court is, and I know that's faulty logic, right? Just because the court's drawing heavy criticism from all sides doesn't mean it's actually doing the right thing. But at a very minimum, it raises the possibility that maybe in offending everyone, the court it suggests that the lower courts aren't trying to curry favor with anyone. But I don't really, the lower court proceedings are relatively opaque to me. It's really hard to know what happened. But if there's something I'm missing in this account of what happened at the lower court level. I mean, I know the part of this percolated up the Constitutional Court in the form of whether the cases could be consolidated. And I know on the one hand there was criticism from the DPP side that, well, you're trying to get this in front of an anti-Chen Shui-bian judge. Then from the KMT side, it's like, my God, you gave it to that judge. She's been sitting on this case for 2 years. This is dragging on and on. Let's put the guy in prison already. Mm-hmm. So, it's hard for me to say whether, I can't really tell, whether the trial court was partial or impartial. I mean, there's no smoking gun as far as I know. And I would be surprised if there were, given the Taiwanese judiciary is a career judiciary. It's not as disciplined as the Japanese career judiciary, where I'd be shocked if judges broke any of the rules as defined by the Supreme Court of Japan. I'd be absolutely shocked. There's a little more horseplay within the Taiwanese judiciary. I think we do know that, and there have been significant, I almost want to call them corruption scandals within the Taiwanese judiciary. So, but my analysis really focuses on the Taiwanese Constitutional Court. And generally the judicialization, and in my defense, I will say that when the judicialization literature talks about courts, it generally talks about the Constitutional Court, because that is the court that's understood as being at the intersection of law and politics. And to some degree, the buck stops with the Constitutional Court. I realize they don't have plenary jurisdiction to review everything the trial court did, but if it were not happy with something the trial court did, it did have the ability to do something about it, right? So, to the extent, I don't know if that's much of a defense, but.
Great. Okay. Fantastic. Any more questions? I have just one quick one for Carl. More of I guess it is a legal question, but if Ozawa is acquitted on the 24th or 26th, I think it's supposed to be, is this the end for this case? Is there an avenue of appeal for prosecutors, or is that it?
Well, this is an open question. Under the civil law system of double jeopardy, prosecutors are allowed to appeal. When the United States was in occupation of Japan, the question was, should the United States amend the Japanese rule so that it replicated the American double jeopardy rule, under which a prosecutor should not be able to appeal. And Dr. Oppler, who was in charge of that, having been a German jurist, saw no reason to change the civil law rule, and so the civil law rule continued. So in Japan, in a normal criminal case, a prosecutor could appeal, and had the prosecutors brought the case against Ozawa, the answer would clearly be yes, they could appeal. The question is whether the prosecutors appointed by the court in connection with the Prosecution Review Commission requirement of indictment can appeal. And I'm not sure what the answer is to that, and I'm not sure in Japan they're sure what the answer is to that question, because this is a very different kind of situation. In the one case in which the defendant was acquitted, there has been no appeal. Mm-hmm. So, that question has not been tested.
Okay, so to be continued, perhaps. All right, so if you'd like to join me in thanking my guests for a stimulating discussion.